Hello, welcome. My name is Jocelyn Walker Collinsworth Meyer. I am the great granddaughter of the head of Perdido, Friendly Creek Indian Chief Frederick William Walker, 1868 and 1941. Chief Fred Walker passed away in 1948, according to the Alabama Supreme Court, and is probate. Contrary to what is published in the Porch Band of Creek Indians History of Chief Fred Walker. The reason why I am producing this video is to bring to the attention not only to my family of Walkers under Fred and Lula Walker, but to bring to the attention of the President of the United States, Congress, the Land Resource Committee, and the Select Senate Committee, and federal agents in which would be interested in the findings of fact of 6 years of research that I alone have endured by putting my life on hold to correct the wrongs and make them right for my family. I am the baby of the tribe in 1984 when we were federally recognized. No one removed me from the roll. I never received a disenrollment letter. There was no, what's the word I'm looking for? I don't even know. There was no reason for me to be taken off the roll at any given time, other than if someone inside the tribe marked me as dead. I'm not dead. I'm making this video, obviously. Those of you who have been paying attention to the issues inside of the tribe, you will notice that there have been many bills that were introduced into the House regarding reaffirmation of the lands in trust. You have witnessed the Oklahoma Creek Nation disputing the building of the casino on the Wetumpka property. There's a lot of history where many of you have witnessed issues regarding the Porch Band of Creek Indians. A lot of newspapers are afraid to publish anything against those in the tribe claiming to have control because they are very threatening, vindictive, and they hold a lot of money. I'm not afraid of you. So I want everyone to listen, pay attention, and take note. The corruption in this tribe, the theft in this tribe will stop today. Anyone who hears my voice, who disapproves, does not agree, you have an issue. Your issue is not with me. Your issue is with your own mind, because you don't know how to handle the truth. Everything that I present to you today is fact. I might throw a little bit of opinion in there because I am affected by what has occurred over the last 40 years. I can't help that. So, Let's begin on the lands in trust issue. I would like to start with a letter written by current chairwoman who claims to have control over all tribal matters, Stephanie Bryan. Letter dated June 27, 2018, regarding the potential revisions of Part 151 Trust Acquisition Regulations, written to the Principal Deputy Assistant Secretary of Indian Affairs, John Tashuda. Let me bring to your attention paragraph 2. Let's start from the beginning. I write on behalf of the Porch Band of Creek Indians to submit the attached comment in response to the Department's initial draft revisions and posted questions about the direction of updates to the 25 CFR Part 151 Land Acquisition Regulations. As you know, the Porch Band of Creek Indians is the only federally recognized Indian tribe in the state of Alabama. Former Interior Secretary William Clark, utilizing authority of the Indian Reorganization Act, the IRA, restored a small portion of the Porch Band's homelands by placing approximately 230 acres of land into trust for the benefit of the tribe in 1984. The tribe also owns approximately 16,000 acres of land in fee simple in the state of Alabama. The tribe provides a wide variety of government services to our tribal members and other Alabamians. And we operate dozens of economic enterprise, both on and off the federal trust lands. I'm going to stop there. Nothing else other than the last paragraph. The restoration of tribal government homelands to trust status is critical to the future of Indian country. Our trust land parcels are the anchor for exercise of the Porch Band's tribal sovereignty, culture, and economy. We appreciate the Department's consideration of the attached comments to improve the Part 151 land to trust process. Now let me ask you, the viewer, why is Stephanie Bryan, quote, the restoration of tribal government homelands to trust status is critical in the future of Indian country. The trust land parcels are the anchor for exercise of the Porch Band's tribal sovereignty, unquote. Well, let me show you why it's critical. In the federal acknowledgement, findings of fact, which are 131 pages long, there is a paragraph in which states, this request precipitated a study ordered by Commissioner Thompson in order to determine the legal status of the land and the history of its granting and transfer. After an exhaustive study by the Office of Trust Responsibilities in the Bureau of Indian Affairs, Commissioner Thompson issued a memorandum to the Associate Solicitor of the Department of the Interior, stating that, quote, a positive evidence of record, quote, unquote, supports the claim that the March 3, 1870 statute had no application to the Lynn McGee Reserve, secured under the 1836 statute. The land claim issue for the Porch Band of Creeks is still unresolved. Now, Commissioner Thompson, if you're still living, and federal acknowledgement, whoever did that evidence of record, I disagree. Because the Indian Claims Commission not only heard for McGee et al. To intervene as the Creek Nation east of the Mississippi corporate entity in Creek claim against the United States for the illegal cession of lands under the patent of Lynn McGee in docket 21, but also for the damages to the Lynn McGee patent. The lands that had occurred, the lands that had received damage, those that directly connected by blood, that had genealogical reports attached to their claim to the land damages under the Act of 1817, do apply in order to show proof that you have title to the lands and are entitled to the payment under the Act of Claims of Friendly Creek Indians paid under the Act of March 3rd, 1817 in docket 272, which is attached to docket 21. This claim of docket 272 is for the original last applicant allottees under first generation. This is my application as an original first generation allottee that got paid for the damages to the lands under the patent of Lynn McGee. Pursuant to the Act of October 19th, 1973, amended January, looks like 12th, 1983, and effective January 25th, 1984. Oh my, what tangle webs we weave. This email is written by Robert Kraft. Mr. Kraft works for the Office of Special Trustee that handles the residual funds going into the tribal trust accounts for the tribe. He and I were discussing after the fiduciary trust officer, Brian Ross, had stepped down as the fiduciary trust officer and moved up in the chain of command, and Mr. Kraft took over his position. Then very shortly after Mr. Kraft took the fiduciary trust officer's position, he then moved up to the next level, whatever that is, in the Office of Special Trustee. In this email, Rob Kraft and I were discussing many things. And in the email, we were talking about the Cobell claim and what have you. But he brings to my attention my docket 272 account. And I quote him saying, "Your IIM account. As we discussed, you have an individual Indian money account currently maintained and administered by our office. This IIM account was created on July 23rd, 1987, to receive a per capita distribution in the amount of $236.15, related to the Indian Claims Commission, ICC Docket 272. This IIM account was created for your benefit since you were a minor at that time. Under ICC Docket 272, approximately $7.7 million was awarded to the Creek Nation as additional compensation for approximately 5.2 million acres that were ceded to the United States under the treaties dating back to 1832. Oh, but no, it was not. It was for the damages. While the ICC Land Claim Docket 272 award was related to certain land claims by the Creek Nation, it was strictly a monetary award. In other words, the resulting monetary per capita distribution under ICC Docket 272 did not involve a distribution of land to eligible recipients. Oh, it didn't? Well, that's funny. I do not agree. Rather, the distribution was compensation for in lieu of lands that were previously ceded to the federal government. No, it was not. Thus, your IIM account has never had any ownership interest in land associated with it. Oh, really? No title claim to be paid? No title claim at all? Don't you have to prove title in order to get payment for anything? Pursuant to the Use and Distribution Plan dated February 16, 1984, a copy of which I have enclosed for your records, the award under ICC Docket 272 is split between the Muskogee Creek Nation and the Eastern Creek descendants. Since there was no federally recognized Creek tribe at that point, February 16th of 1984, the award was made payable to the Eastern Creek descendants, and the Secretary of Interior was directed to bring current a descendant payroll that was previously utilized for a per capita payment by, and among other things, added qualified individuals born after the prior descendant payroll. This is how you became eligible to receive the per capita payment for ICC Docket 272. Really? Let's pause here. So I want to bring to your attention where Mr. Kraft said the distribution plan dated February 16th, 1984. Okay? Distribution plan. February 16th, 1984. Well, on January 7th, 1987, I received a letter. It says, the Act of 1973, 87, Statute 466, as amended January 12, 1983, by Public Law 97-458, directs the Secretary of the Interior to preserve and protect the per capita share of minors. Regulations for carrying out this trust require that a per capita share of judgment funds which exceeds $100 in total at the time of the actual payment is made, including the investment income accrued thereto, for a minor child shall not be distributed until the minor reaches the age of 18. Funds held in trust may be spent under a plan by their parents or legal guardians for health, education, welfare, or emergency situations. Such plans must be approved by the Secretary of the Interior and the tribal governing body, and shall be limited to urgent needs arising from extenuating circumstances. But take a closer look. This letter is to verify that your share of the Eastern Creek per capita payment from Docket 272 in the amount of $236.18 in deposit is deposited into an individual Indian money account and is presently drawing interest as set out in the Act of June 24th, 1938, 25 U.S.C. 162A, which authorizes the Secretary of the Interior to invest Indian tribal trust funds. These monies are going into the tribal trust funds, right? Okay. Now let's take another look. Let's take a look at the Act of March 3rd, 1817. Sorry, I tried to do this before, but it wouldn't stick. So here's your Act of March 3rd, 1817. An act to set apart and dispose of certain public lands for the encouragement of the cultivation of the vine and olive, be it enacted by the Senate and House of Representatives of the United States in Congress assembled, that it shall be the duty of the Secretary of the Interior, under the direction of the President of the United States, to designate and set apart any 4 contiguous townships, each 6 miles square, of vacant public lands lying in that part of the Mississippi Territory which was formed into a land district by the act entitled An Act for the Ascertaining and Surveying of the Boundary Lines fixed by the treaty with the Creek Indians, and for other purposes, passed on the 3rd day of March, 1815, and the 4 townships so designated and set apart shall be reserved from public and private sale. Anything in the aforesaid act to the contrary notwithstanding. Section 2. And be it further enacted that the Secretary of the Treasury be and he is hereby authorized to contract for the sale of the said 4 townships, which shall have been designated and set apart, as an aforesaid, to the rate of $2 per square, to be made payable 14 years, not just a one-time payment, 14 years. Let's go to the next page, maybe. After the contract shall have been concluded with any agent or agents of the late immigrants from France, who have associated together for the purpose of forming a settlement in the United States. And that immigrants from France, yeah, that the satisfactory evidence shall be produced that such agent or agents are duly authorized to form such contract, and that the number of such immigrants being of full age for which he or they are authorized to act, to equal at least to the number of half sections contained in the 4 townships proposed to be disposed of. And be it further enacted that the said Secretary shall have power to make such allotment of lands among the individuals, and to stipulate in the proposed contract for such conditions of settlement and cultivation of the vine and other vegetable productions as may to him appear reasonable, and that on the fulfillment of such conditions shall the issuing of grants for the lands be made to depend, provided that no patent shall be granted for any of the lands aforesaid, nor shall any title be obtained therefor, either at law or equity until complete payment shall have been made for the whole 4 townships, and until they comply with the conditions of the contract, so to be made as aforesaid. Nor shall a patent be granted for a greater quantity than 640 acres to any one person. That, Mr. Rob Kraft, is docket 272. Now, let's take a look at why Mr. Rob Kraft has an issue with understanding our Creek heritage, how the lands even came about to be an Indian fee patent. Let's take a closer look. So, why does OST, the Office of Special Trustee, have an issue with recognizing the history of the land grant under the patent of Lynn McGee? Because, as you will notice, February 26, 2002, the Management of Indian Tribal Trust Funds testimony presented before the Senate Committee on Indian Affairs, Mr. James T. Martin, Tim Martin. I'm an enrolled member of the Porch Bannock Creek Indians. I am also the executive director of USET, United Southeastern Tribes, an intertribal organization consisting of 24 federally recognized Indian tribes from 12 states in the South and Eastern regions of the United States. USET's primary function is to provide a forum for the exchange of information and ideas among its members, the federal government, and other entities. Mr. James T. Martin, a member of the Porch Band of Creek Indians and executive director of USET. On behalf of USET, I have afforded the opportunity to serve on the trust reform task. So why does Mr. Robert Kraft have an issue with the history of the land grant? Could it be perhaps that Mr. James T. Martin informed the Office of Special Trustee improperly, illegally, and deceptively about how the land grants actually took place? As you're aware, the Trust Reform Task Force was established after the Department of the Interior Secretary Gail A. Norton presented the Bureau of Indian Affairs, the Bureau of Indian Trust Asset Management, BITAM, reorganization proposal and received widespread opposition to the proposal. The one point that Indian Country and the Secretary are in agreement with is that the trust reform is a top priority and extensive change must take place to facilitate a solution. Well, how are you going to facilitate a solution when you have people that are over the reform giving false information? Mr. Martin, I have a big bone to pick with you on why you lied to the Office of Special Trustee about reforming these accounts, saying that docket 272 under the March 3rd Act of 1817 was not the allottees. This information was sent to Gerald Gidner, the Office of Special Trustee head of the department, and Jason Bruno, the historical class director over the Cobell settlement in the office of special trustee. Neither one of these two men could comprehend that they were informed improperly, falsely, and deceptively regarding the docket 272 IIM accounts. I would like to also bring to your attention a newspaper article, and anybody can go. It is a paid site, but anybody can go subscribe for free for 7 days and look up the news articles themselves. But you have the same article posted in the Pensacola News, Wednesday, June 13th, 1984, Florida Today, February 12th, 1985, another Pensacola News, January 12th, 1985, yada yada. But to pull out this article, I'd like to read it to you. The porch band is, let me start this, okay? The Bureau, in a public statement dated January 30th, determined, and this would have been 1984, January 30th, 1984, determined about $2 million from what is known as Docket 272 should be split up equally among all creeks in the eastern United States. The agency rejected the bid by the Porch Band of Creek Indians, based near Atmore, Alabama, about 40 miles northwest of Pensacola, to obtain all the money. But the Bureau ruled in favor of the Alabama tribe on about $200,000 from Docket 21. That was just for the remaining funds after those that had passed away or those that could not be located that were on a whereabouts unknown list. That remaining overage was given to Porch under, I believe it was statute HR 1224. I do not think the drama has closed on it yet, said Don Sharon of Fort Walton Beach. Sharon is the council chairman of the Florida Tribe of Eastern Creeks, known today, or at one point, as the Bruce Tribe. Today, I believe they are known as the Miccosukee Tribe, perhaps, which about 1,000 members of the Florida Panhandle and is seeking federal recognition. They still haven't received federal recognition. The Porch Band, numbering about 1,450, which is wrong, it's 1,470, and now in the process of building a bingo hall on its lands, is the only recognized Creek tribe east of the Mississippi. There are about 7,500 other creeks in the east, but no other recognized tribal groups. D.B. Ott, director of the Eastern Area Office of BIA in Arlington, Virginia, said a federal law passed last year which requires all remaining Docket 21 money marked for Eastern Creeks go only to recognized tribes. The Porch Band was the only one fitting that description. But, he said, the law doesn't cover Docket 272. Therefore, those funds would be split up among individual Indians, as done with the past distribution, except, and I highlight, except for Porch members. Their money instead would go to the tribe. Tribal Chairman Eddie Tullis of the Porch Band was out of the office and unavailable for comment Monday. However, in past statements, he has challenged the authenticity of Eastern Creeks who aren't members of his tribe. Sharon said he expected the Porch Band to continue what lie called a grab for bigger money. The policy letter signed by Ott has been submitted to the Assistant Secretary John Fritz. Ott said he assumed anyone dissatisfied with it could appeal to Fritz, but he didn't believe Fritz would disagree with him. Sharon said his group was reviewing possible legal action. That would be the Bruce tribe. He contended the law giving the Docket 21 money to the porch band was unconstitutional, arguing that Congress doesn't have the power to take Indian money from one group and give it to another. He also said he hopes to meet on the issues with Florida U.S. Representative Earl Hutto. Okay, one moment. Well, the Pensacola tribe, Bruce tribe, Miccosukee tribe, they did appeal. And this is the case where they appealed. Let's find where they're discussing Docket 272. Today, the official tribal membership roll, talking about their tribe, lists almost 1,800 active adult members, many still alive either on or near the original Creek homelands, first settled in the early 1800s. So the Docket 272 had a lot to do with their tribe as well. Okay. Okay, so I'm going to start right here talking about their tribe, the Florida tribe, Miccosukee tribe, Bruce tribe. The membership criteria for the Florida tribe is very specific. Citizens are either documented by genealogy to descend from one or more ancestors that are listed on the southeastern Native American rolls of former Creek Confederacy towns established by the federal government, or they meet the eligibility requirements of these federal rolls but do not necessarily appear on them, such as the Eastern Creek rolls. So eligibility is by birth. For example, individuals who applied for and were accepted under Docket 21, 272, or 275 for the per capita distribution of the Creek land payments are eligible under the membership requirements for the Florida tribe. There are some cases of membership by affidavit, but these are relatively few and require multiple sworn affidavits signed by tribal elders. Okay? But let's get down to the disagreement. Let me find it. Okay. March 24th. And I do believe this would have been somewhere 1984, 85. Yeah. Tribal meeting in Bruce. Various items were briefly discussed, including tribal newspaper articles, reports on endowment funds, and Governor Council on Indian Affairs. Florida tribe also passed a resolution that authorized the tribe to represent its citizens for Docket 21 and 272 before Congress, the BIA, or any other courts and legal entities having jurisdiction affecting disbursement of these monies. April 28th, tribal meeting in Bruce. You can't quote me on the year of this because there's no year dated, or it's not on here. So Tribal meeting in Bruce, Dr. Andrew Boggs of the Apalachicola Band had been seated on the Governor Council on Indian Affairs. Chairman Sharon had appealed on behalf of the Florida tribe to the Assistant Secretary of Indian Affairs regarding, okay, so yeah, this is in 1984. Regarding Porch Creek's receiving residual docket 272 monies. Oh, did Rob Kraft say that it was a one-time payment? Did I not show you that the act of March 3rd, 1817 was residual funds? It occurred for how many years? 13, 14 years? The appeal on docket 21 monies was denied. Well, so on November 10th, on the appeal, denial of docket 21 residual funds for the Pensacola tribe, a motion was made and passed that the Florida tribe would appeal the docket 21 denial. Decision was presented regarding a meeting with the BIA and the Porch Band of Creek Indians to find a reasonable distribution or solution for the distribution of docket 21 monies. Or excuse me, I'm sorry, I am really messing up here. Docket 272 monies. The motion was presented and passed that the chairman of the Florida tribe, chairman of the Northwest Florida Creek Indian Council, and the Florida tribe's attorney negotiate a meeting date with Porch and the BIA to pursue this activity. The tribe's constitution was amended as well. Talking about the Pensacola tribe. Okay. Okay, so this is the actual case with the Florida Tribe of Eastern Creek Indians versus the Deputy Assistant Secretary regarding the distribution. This is 10/10/1985. So the distribution plan that was proposed by Porch, that was rejected by the Bureau, was this. On January 30th, 1985, the Eastern Area Director of BIA informed the Assistant Secretary of the Indian Affairs of his decision concerning the disposition of funds in docket 21 and 272. The memorandum indicated that the residual funds in docket 21 would be distributed only to the Porch Band of Creek Indians, Atmore, Alabama, and it established a distribution plan for the funds in docket 272. On February 28, 1985, the appellant sought review of the Eastern Area's Director's decision. The notice of appeal states, we feel that since the Eastern Creek share in docket 21 funds was voted by the Eastern Creeks in 1973 to be distributed on a per capita basis, that the residual monies of the docket 21 should be paid out in the same manner. We feel that this is not federal money. Okay, so it was not federal money when the court awarded this payment to the Creek Indian people. We concur with the Eastern Area's ruling on docket 272, except that those people presently on the Porch Band's roll who wish to remove their names from the roll and receive their per capita share in docket 272 funds be allowed to do so. On April 4th, 1985, the appellee affirmed the Eastern Area Director's decision. The present appeal was received by the board on May 13, 1985. Briefs have been filed by both appellant and appellee. This decision is being expedited on the basis of congressional concern, expressed in letters to BIA, copies of which are provided to the board. Okay, so as you see here, here's some dates. On January 30th, 1985, the Eastern Area Director informed the Assistant Secretary for Indian Affairs of his decision concerning disposition of Docket 21 and 272. Let's take a look back at the application and see exactly what is on that application for the distribution plan. Okay, February 16th, 1984, and I'm quoting Robert Kraft. Pursuant to the Use and Distribution Plan, February 16th, 1984, a copy of which I have enclosed for your records, for Docket 272 was split between the Muskogee Creek Nation and the Eastern Creek descendants. I'm sorry, Mr. Kraft. No, it wasn't. As you see in the previous, on January 30th, 1985, the Eastern Area Director, I'm sorry, that was a whole year later. That's a whole year later. So we have some problems here. Okay? Then I look at the Federal Register. And on the Federal Register, and as I told Mr. Kraft, you cited something from February 16th, 1984. However, as to the Federal Register, Volume 49, Number 40, Tuesday, February 28, 1984, where pursuant to the Act of September 21st, 1968, and approved October 20th, 1972, by adding the names of persons living on the effective date of this Act, but who are not enrolled, by adding the names of the children born on or prior to and living on the effective date, yada yada, deleting the names. Come on. There's distribution. Where's the distribution? February 28th. Yeah. That's not what the application said. Nobody said that anybody could take anybody off the roll. I'll tell you, if I can just kind of start right here again. Second award was made, Docket 272, September 22nd, 1978. Funds were appropriated for payment of the award December 11th, 1978. A preliminary plan for the distribution of these funds was developed by the Bureau of Indian Affairs and approved by the Secretary of the Interior on January 25th, 1984. Apparently, no distribution has been made from this docket. On January 30th, 1985, the Bureau of the Eastern Region Director of BIA, January 30th, 1985, informed the Assistant Secretary of Indian Affairs of his decision concerning the distribution or disposition of the funds in Docket 21 and 272. The memorandum indicated that the residual funds from Docket 21 would be distributed only to the Porch Band of Creek Indians at Moore, Alabama, and it established a distribution plan for funds in Docket 272. On February 28, 1985, the appellant sought review of the Eastern Area's Director's decision. The notice of the appeal states, we concur with the Eastern Area's Director's ruling on Docket 272, except that those people presently on Porch's roll who wish to remove their names from the roll and receive the per capita share of distribution and 272 be allowed to do so. On April 4th, 1985, appellant affirmed the Eastern Area's director's decision. The present appeal was received. Okay, so if the Eastern Area director had approved a distribution plan January 30th, 1985, then Mr. Rob Kraft, that's not it. Mr. Rob Kraft's statement to me that my IIM account was created and distributed based on the February 16th, 1984 distribution plan is incorrect. So, it's not February 16th, 1984. So let's find out what happened between January 30th, 1985 and go back to B. If that was January 30th, 1985, I'm going to go back to the news article and see, once again, this is a public statement, January 30th. January 30th. Here you go. January 30th. So if on January 30th, the Bureau released a statement rejecting Porch for receiving all the money, but that the tribal members' monies would go to the tribe, that means that those are tribal trust funds, right? Tribal trust funds. And therefore, the letter from the secretary here, with my name on it, says these are Invest Indian Tribal Trust Funds. Ooh, imagine that. Now I would like to show you the meeting minutes between the dates of when the rolls were submitted during federal recognition and what happened, what actions were taken after the rolls went into federal acknowledgement. Director Lee Fleming. Okay. So these are the meeting minutes. And they do have typos. I did not create them. These were given to me by a current tribal member because they were in agreement. See, like this right here, 1974. This is not 74, it's 1984. There's, whoever was taking notes during the meetings, they took fairly good notes. So let's find some things. I'm going to go off the subject of the docket 272 until I come across it again. This is based July 22nd, 1984. July 22nd, 1984. So this is after the purported as approved Constitution was ratified by the majority tribal members. So the next item on the agenda was the report from the Bureau of Indian Affairs on-site visit. No, I take that back. This is 1984, not 1985. Sorry to confuse you. And if I can delete this part, I will delete this part. And start again. So this is July 22nd, 1984. The next item on the agenda after the two rolls went in was a report on the Bureau of Indian Affairs on-site visit. Mr. William Ott, Acting Area Director of the Eastern Area Office, Mr. Robert Benn, Superintendent of Choctaw Agency, Mr. Tom Bond, Trust Officer for Office of Special Trustee, Dr. Diane Cutchins, Choctaw, Miss Sarah Mott, BIA Personnel Officer, Mr. Ray Thomas, Choctaw Area Agency, Mr. Tullis, and Miss Gavy Drew spoke with Mr. Ott on the process of conveying land into trust. The process has been started on 5 of the 8 parcels of land that we are hoping to get into trust status. Mr. Tullis then reported that this tribe has to adopt a constitution. The tribal council did approve a proposed constitution, and it was presented to Mr. Ott. We asked that the superintendent of the Choctaw Agency, Robert Benn, conduct an election for the adoption or rejection of the Constitution. At this point, we have not received a response from Mr. Benn thus far, but the proposed Constitution is being reviewed by the Bureau, and if they approve it for a vote, then the BIA will call a constitutional election. Sorry, it's not a constitutional election, it's a secretarial election. Here for the Porch Band of Creek Indians. Mr. Tullis also made an official request to Mr. Ott to certify the present governing document as the governing unit for the Porch Band of Creek Indians from August 10th, 1984 until such time that a constitution is adopted. This certification has to come from at very least the Assistant Secretary of the Bureau of Indian Affairs. Mr. Ott was also given a copy of the Porch Creek Indian Housing Authority, yada, yada, yada. Okay. Well, so the past council from August 10th, 1984 until such time that the Constitution is adopted at a secretarial election, which in the previous letters it says that that time had expired, and then the second one said that, or they did extend that time frame, but that time frame is well expired. If we want to assume that because a secretarial election has never happened to approve the organic document, that council still has authority? I think not. Yeah. So, let's go down. This is where they were drafting the Constitution. Here we go. Here is where it says 7/9, the clerical error. 7/9/1984. Adoptions and member eligibility. Oh, wait. 7/9/1984. That's before council has authority. Oh, my goodness. The review of Article 1 continued. Section 4, adoption and loss of membership. Excuse me. There was a reference to the tribal council meeting held on September 19th, 1982. At that time, there was a motion approved which in part states that adoptions prior to 1979 shall be accepted as members, and that since 1979, each applicant must meet 1/4 degree requirement. Like I said, this is before the request. So even if you want to assume that council still has authority because no secretarial election has ever been held to approve the Constitution under the IRA for the distribution of the tribal trust assets, then Council had no authority to add anybody to the roll or remove anyone to the roll or from the roll. Okay, let's keep going. Here they are, branches of government they're creating branches of government, assuming branches of government in the merger. You can't do that. I mean, come on. This alone is enough to show that there is major fault in the people who were sitting as council during this time period. Okay. Here we go. Tribal Council Minutes, 8/18/1985. The BIA recognized the Constitution as the tribe's governing document. Since when did the Secretary of Interior, at this point in time, in the past, in 1985, grant the authority to the Bureau to recognize a tribe's governing document without having the approval of the Secretary, without a secretarial election? Next was review of a letter of acceptance of the Constitution of the Porch Band of Creek Indians as the governing document of the tribe. Chairman Tallis reported the letter from B.D. Ott, Area Director, dated July 26, 1985, recognized the Constitution as the governing document for the tribe. But due to the June 1st, 1985 election not being a secretarial election, that organic document was not approved under the IRA. Okay. July 26, 1985. July 26, 1985. When was the letter written by the Deputy Assistant Secretary? Nope. Not it. Right here. November 22nd, 1985. And July something. I hate doing it like this. Okay, I'm stopping. I'm getting aggravated.